Okay, we'll get started. Welcome to Navigating New Norms, Understanding the Proposed H-1B Changes. My name is Katherine Del Rosario. I'm an attorney here at McEntee Law Group, and I'm joined by my teammate, Dan Rock.
Hi, everyone.
Welcome, everybody. Thanks for taking the time to learn about some new possible changes with the H-1B program. Last month, the Department of Homeland Security proposed changes to modernize the H-1B program as we know it. And if your company or organization has H-1B employees, these changes may have a significant impact on your team, your recruitment strategy, the way that you hire, and your compliance practices. So just so you know, the rule is, it's still a rule. Well, it's still a proposed rule. And it's open for public comment until late December, after which the DHS will have time to review and respond to any comments they receive. The final rule may take effect as early as the next H-1B lottery cycle, which will start in March 2024. So today we will provide an overview of the major changes proposed in the rule and our thoughts on how they could possibly impact the H-1B program. If you have questions during the webinar, please utilize the Q&A feature. We've reserved time at the end to address those questions. Okay, I'm going to hand it over to Dan to start with our first section on modernization and efficiencies.
But before that, I want to give the disclaimer that while we are attorneys, we're not necessarily your attorney. This is for informational purposes. And if you would like to discuss your specific H-1B needs, please feel free to reach out to us for a consultation. Moving on. So the first big section of the proposed regulations are on the modernization and efficiencies within the H-1B program. The first big change is revising the definition of specialty occupation. There needs to be a direct relationship between the degree, but you could have a range of degree fields. So for your software developer, you might have degrees of software engineering or information technology. For jobs where a disparate type of degrees could be required. For example, like if you have a chemistry teacher, you could require a degree in education or in chemistry. You will need to show the relationship between kind of the disparate degrees and the position itself. With the example I gave of a chemistry teacher, it might be somewhat obvious, but given individual jobs, it might be less obvious and you might need to explain it more. Additionally, the definition confirms that the normally language, so normally requiring a degree doesn't mean always requiring a degree. We had a period of time where the USCIS was very much a stickler for looking at positions where the Occupational Outlook Handbook said that a degree is normally required for any given position, and they were sticklers for saying that if it wasn't always, then it wouldn't fall within the definition of specialty occupation. So the updated proposed regulations confirm that normally does in fact mean normally, so we appreciate that. Moving on to the next slide. It does provide some additional guidance on when to file an H-1B amendment in situations where you need a new LCA, such as going to a third-party worksite within the same metro area. you would need to file a new H-1B amendment or a relocation to area outside of the metro area that was initially certified within the LCA. You would need to file a new H-1B amendment for that position. That this wouldn't affect short trips for employee development activities or that type of position where there is just a short trip to one area or another. So that is also added to the proposed regulations. Moving on to the next slide. The proposed regulations codify the deference to previous petitions where there's been no material change in the underlying facts of the H-1B petition. This is really streamlines the process for extensions or amendments where the changes are minor or superficial, such as like a title change without significant change in duties. It has been the policy of USCIS for most of the time I have been practicing immigration law. During the prior administration, they did remove this deference, and it added to processing times and the number of requests for evidence that we received on cases where you would normally not expect to see that. So having it codified within the regulations will be beneficial to kind of keep any change in this policy from being kind of at the whim of the administration. They would have to go through the regulatory process to change that. So we are welcome to see this in the proposed regulations. Moving on. And then the proposed regulations require proof of maintenance of status with H-1B extensions and amendments. That's like pay stubs, W-2s, tax returns to show that you're working in a manner consistent with your H-1B petition. This is something that we typically provided throughout the process. So it probably won't change much on a day-to-day basis from what we do, but it is now required as initial evidence. So it could affect cases that don't include that information. That is kind of the crux of the first section of the proposed regulations on modernization and efficiencies. I will pass it over to Katherine to go through the next section of the proposed regulations.
Yeah, so it sounds like with this first bucket, there may be additional requirements for employers to meet, but the hope is that it helps move cases along more quickly. And it also shows, the regulations are sort of catching up to what the reality is in the workplace and in this market.
Yeah.
The second kind of bucket of changes has to do with benefits and flexibilities for both employers and employees. The first one is probably my favorite of the changes. I love to work on cap exempt H-1B cases. And the rule it proposes to expand the definition of cap exempt employment. So the DHS is proposing to modernize the definition, which would create more flexibility for employees that are working at qualifying cap exempt employers. So the type of employer that qualifies isn't necessarily changing, but what I'm thinking of is a nonprofit or government research institution. And historically, it was kind of a challenge to prove the research purpose of an organization without the actual research product. But under this new rule, cap exemption will be determined by whether research is fundamental as opposed to a primary activity of the organization. Fundamental, even though it might not seem like it, is an expansion of that term primary. So let's say you are at an organization, or your organization does research, but it's not the only thing that you do. Perhaps you do policy work or direct service. This change would allow you to consider, maybe you are a cap exempt entity, and that way you may be able to welcome H-1B employees without having to enter the lottery. The lottery limits you to only, submitting registrations that one time of year, March, and then you're out of luck. But if you are considered cap exempt, then you can hire any time of the year. On the employee side, the new rules propose that beneficiaries may qualify for cap exemption even if their role does not further the research function of the organization. I think this was probably already happening in practice, where if the beneficiary, let's say, is doing more of an accounting or finance role for the research organization, there may or may not have been a challenge there. But here it kind of lays out more clearly that the role doesn't necessarily have to further research or be research related to qualify for cap exemption. So that's a great thing. Okay, the next change, I think, is also very welcome by employers and employees alike. It will expand automatic extension of F1 OPT cap gap. What does this mean? So for former students who are transitioning from F1 to H-1B, they likely have a work permit that has an expiration date. And when they're filing the H-1B petition, as long as they're filing it before the work permit expires or before the end of June of that year, their work permit will automatically get extended to October 1st, which is the typical start date for H-1B, so that they can continue working and have status. The new rule will expand, it will extend that date to April 1st. So if an H-1B petition is filed in June next year, then the beneficiary will receive cap gap or continued work authorization until April 1st the following year, 2025. So students would avoid any disruptions in their status or ability to work while they're waiting for that H-1B to kick in. This could also mean cost savings for employers who may not necessarily need to utilize premium processing, which we know is expensive. It's $2,500 for now. But with this flexibility, you could consider just filing under regular processing. The last change that I'll cover has to do with start dates. So as I mentioned in the last slide, H-1B cap cases typically start on October 1st, but this new rule would allow employers to file cap petitions with a start date after October 1st. So, but still within that fiscal year. So one situation where this might come up is if a beneficiary has been selected in maybe a second or third lottery that's perhaps after October 1st. So to be able to pick a start date that's after that, that employee won't lose out on the time that they're entitled to. Okay, I'm handing it off to Dan to cover the third and final bucket of changes relating to program integrity and prevention of fraud.
Yep. Starting with the H-1B lottery, USCIS has indicated that these regulations may come out on a rolling basis. I think the goal and expectation is changes to the H-1B lottery will take effect prior to this upcoming H-1B lottery period. As a bit of background, this past year for the H-1B lottery, there are a limited number of cases, and they have a lottery for all new potential H-1B cases that employers register for prior to April 1st. And once cases are selected, then the employer can apply for beneficiaries, H-1B status starting October 1st or later with the proposed changes that Katherine just discussed. Moving forward, they're talking about, rather than basing it on the employer registration, they would have the lottery entrants determined by beneficiaries. So one beneficiary would only be entered once, no matter how many companies submitted registrations for that beneficiary. This past year, there was evidence of abuse. There were applicants with over 50 registrations with various companies. So this is kind of a welcome change for beneficiaries and companies that are doing things the right way and have bona fide job offers for the employees. Related entities are prohibited from submitting multiple registrations for the same beneficiary. This is because when you are registering, you have to kind of certify that you are registering for a bona fide job offer. And the same entity can't be making a bona fide job offer to the same person. They really need to select one particular job to offer the proposed beneficiary. And this codifies USCIS's ability to deny or revoke H-1B petitions or approved petitions based on fraudulent information in the registration. So this is really trying to get at the people that are abusing the registration system. Under this new proposed system, if a beneficiary is selected and there's more than one job offer, the beneficiary would have some increased bargaining power between potential employers. So that is one benefit to foreign nationals in these proposed regulations that companies might not be as keen on, but that it does provide the beneficiary with some choice between employers if they are registered for more than one company and get selected in the lottery. Moving on. The proposed regulations provide some information about third-party work sites. This is an area that USCIS is always kind of has a cautious eye towards, because it's an area that does lend itself to abuse. So that with third-party work sites, Department of Homeland Security will rely on the third-party client's requirements for a position rather than the petitioning entity. So if a petitioning entity requires a bachelor's degree, but it's to fill a role that a third-party worksite doesn't require a bachelor's degree, that would not meet the definition of specialty occupation. Similarly, for these third-party worksites, USCIS is going to require evidence of the relationship, such as master service agreements, work orders, or funding documents. So that is something that we would typically submit, but now the proposed regulations codify USCIS's ability to ask for this sort of information. Moving on to the next slide, one additional kind of huge change to the program, is changing the ability of immigrant entrepreneurs to seek an H-1B status with a company that they own a controlling stake in. Prior to these proposed regulations, or until these proposed regulations are in effect, the H-1B program looks at whether there's an employer-employee relationship. The language of the proposed regulations kind of moves away from that and focuses on a bona fide job offer. Compliance with the position under H-1B rules, including paying the prevailing wage in the LCA. There's also a requirement that the petitioning entity have a U.S. presence and can accept service of process. So this is kind of a huge new benefit to foreign entrepreneurs that want to start a business and would otherwise qualify for H-1B. This allows them to go through the H-1B process rather than looking at other options that might not work quite as well. So moving on, the kind of final piece of the program integrity puzzle is codifying USCIS's authority to conduct site visits and clarifying the scope of these. They make note that they will have the right to look at third-party work sites, and third-party are required to comply with these for H-1B employees. And if they fail to comply, or if third parties or the petitioning organization fail to comply, it could result in a denial or revocation of the H-1B petition. So this is kind of codifying practice that USCIS, they already do site visits. So this is kind of the regulations catching up to actual USCIS's practice in this area. But it does provide some clarification on that as well. As Katherine mentioned, these regulations are not final. We are in a comment period. So if you have questions or concerns about these regulations, you can leave a comment with the Department of Homeland Security. And we've provided the website link. It is kind of difficult to find this website, the specific USCIS document on the website. So if you do want to leave a comment, just copy the link that we've provided. And there's a like blue button on the screen that says comment, and you essentially just click on that and you can leave your comments. So if you have comments about the H-1B program, please feel free to leave a comment for U.S. Department of Homeland Security review on that website. So I believe that will wrap up the kind of overview, and we will move on to questions and answers.
Yeah, I see a couple of questions coming through. Just as a reminder, can you please put them in the Q&A section rather than the chat, so we can just track them better. As those start coming in, I guess just to sort of summarize what we're seeing in these proposed changes, it's definitely USCIS catching up again to the reality of the current workplace and sort of modernizing, how employers really consider potential applicants. And, it's not just degrees that they look at, it's also their skills. So having that flexibility in the recruitment process is wonderful, and expanding on the definitions of specialty occupation, of CAP exemption. This will all allow for more people to enter the H-1B program, we hope. I think it also emphasizes program integrity. What I mean by that is what, you know, a lot of these changes are sort of just making official what USCIS already does. And what they're really concerned with is is what was laid out in the original H-1B petition really what's happening? I think, that's the key thing. So when we see a change in the rules about site visits, it doesn't mean they've never done site visits. They have, and they have revoked approved petitions or denied pending petitions if there is, any like instances of fraud. That's not new, but it sort of just it highlights that fraud is a real thing in this area of the law. And so what is written into the H-1B case must be carried out by employer and employee.
And like kind of building off of Katherine, like this codifies it. So it will, probably prevent court cases on these issues a little bit. Like with the specialty occupation, we have traditionally been able to link closely related degrees, but there have been instances where an individual officer would question whether information technology or computer science are related. So that's like just kind of making these a little more consistent should be helpful moving forward. We do have a couple of questions. Can you explain again how the petition being linked to the beneficiary gives the beneficiary negotiating power if they have more than one job offer? So in this instance, how it occurs now is each individual registration is entered into the lottery. So if a beneficiary is registered for two different companies, they would have to be selected by one of the registrations, not necessarily both of the registrations. So if they're selected by one company that registered for them, they would have to take that job or not go in the H-1B. Under the proposed regulations, as they're tied to the beneficiary, not necessarily the company, that would potentially give the beneficiary a little more power to choose positions after the registration period, if they are selected in the lottery to go to one of the companies that's registered for them. So that's again, it's going to be very specific on individual circumstances, but if there is a situation where beneficiary is chosen and has more than one job offer from a company that registered for them, they would have a little more power to pick and choose which position they go to.
Yeah, so like if, for example, company A, B, and C all put in the same beneficiary into the lottery, under the old rules, if beneficiary was only selected by company B, or USCIS only selected the company B entry, then that beneficiary doesn't really have a choice except to go with company B in order to be counted in the H-1B cap. But under this new rule, let's say company A is paying more or is in a more, preferred location or in an, more advantageous like position or role, then the beneficiary has, the bargaining power and the leverage to and the agency to choose which company they want to go with, because now the lottery is centered on them rather than the employer. So hope that answers your question. The next one I see is for immigrant entrepreneurs, is it the regular cap H-1B or cap exempt? So this would apply in either situation because it's going to be the same form that's used with regular cap or cap exempt. And on the current form, there is a specific question about whether beneficiary has a controlling interest in the company. And we read the new rule as saying that question will no longer be there. So it won't really matter whether it's cap or cap exempt. Okay. I see. I'm just going to check the chat real quick. Bear with me. Okay, there's one question here. What's the difference between the entrepreneurial H-1B and the O visa? Dan is our O guy, so I'm going to give you that one, Dan.
Okay, so the O has different requirements. That is for extraordinary ability, which has traditionally had the ability to petition through an entity that you wholly own. The proposed regulations essentially expand that into the H-1B arena. So for an individual that might not necessarily be able to meet the requirements for an O visa, but would meet the requirements for the H-1B, this really does expand the ability to work in the U.S. for your own company. So the biggest difference is kind of the requirements for H-1B have to be met for the H-1B, whereas with the O, the person needs to qualify for the extraordinary ability. So even if you're starting your own company, you'll need to meet the prevailing wage requirements, that sort of thing, have to work in an area that requires a degree in a specialized field. The biggest difference is in the requirements for the individual visas, but this allows the company owned by the foreign national to be the petitioning entity in either case.
I'd also note that H-1Bs start at 3 years and renewable for another 3, but they're maxed out at 6 years. And correct me if I'm wrong, Dan, but O's do not have that limit. You do have to renew it, but
yeah, O's don't have that limit. There's also H-1B is considered a dual intent visa type where you could intend to work in the green card process, whereas O does not speak to immigrant intent. It doesn't officially allow for immigrant intent. So if you file your adjustment of status with an H-1B and need to travel, you could travel on your H-1B visa without abandoning your green card process. Whereas with the O, you would need to get a travel document separate related to the adjustment of status before you would be able to travel internationally. So that would be something that we would be able to advise on a case-by-case basis. Travel issues around green card processing are always an issue, regardless of H-1B or O visa, but that would be kind of an individual basis to kind of discuss in further detail.
Yeah, so just to summarize, on the H-1B side, you're looking at the standard is specialty occupation. You are you max out at 6 years, but it does have dual intent where you could be pursuing a green card at the same time. On the O side, it's extraordinary ability. It's renewable indefinitely, but it's only temporary intent, that non-immigrant intent.
We have a question in the Q&A about whether the cap will remain the same or if there's anticipation of it increasing as a result of these changes. These changes do not affect the total cap number, except for, as Katherine was discussing, more organizations will likely qualify as cap exempt, which should alleviate a little pressure on the H-1B cap. Some changes to the lottery may make it a little easier to get through the lottery if you're an employer that is just looking to employ a person and not someone that is trying to game the H-1B lottery system. So that should be a welcome benefit to most people that aren't trying to game the lottery. But the total cap is set by statute, and that would take an act of Congress rather than agency action to change the actual H-1B cap.
Okay, I don't see any more questions, but I'm sure they're out there. But thank you for joining us. I know this was a lot of information. We just hope that you have a better understanding now of the impact that this rule could have on your organization, your immigration program, and your team and your colleagues. I would note that the proposed changes will impact every company and every employee differently. So our suggestion always is to seek legal advice, but we are happy to extend a discount on our consultation fee for anyone who has attended this webinar. And then we can provide more customized guidance and legal advice for you. Will you send a recording? A recording will be available. Yeah, so we're being recorded now. And one more question here, when do you see these changes go into effect? Well, as a reminder, we're in a comment period now, which will last until December 22nd. And then after that, the DHS has an opportunity to respond and revise the rule. We anticipate that it will take effect before the next cycle, the next lottery cycle, but we have to wait and see.
Yep. And DHS has indicated that they may put different sections into effect at different times. So the changes affecting the H-1B lottery might go into effect before some of the other changes. But we are in a period where they are still accepting comments on this. So if there is something that you like or don't like, we do encourage you to reach out to DHS to provide a comment.
Yeah, and this is sort of like a one-on-one 101 on civic engagement, I guess, because this public comment process is available to individuals and organizations and companies alike. So using this link, you can provide your feedback, you can ask for the things that you want, you can speak up about the things that you don't. So we encourage you to engage in that process. Okay, thank you again, everyone, for joining us. Please follow us on all of our social media platforms. We are constantly updating there and responding to changes in policy and law and just immigration news in general. But thank you, everyone who has joined us. Again, this will be available for as a recording later on. So thank you so much. Bye-bye, everybody.
Thank you, everyone. Bye.